Hello and welcome everyone to Immigration and Jobs Talk Show. Thank you so much for joining us across all platforms, whether you have joined us on YouTube, LinkedIn, or Facebook. And I have this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, a very warm welcome to each and every one of you to Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan, and we're really thrilled to have all of you joined in today in today's webinar. So, today's topic is actually one that creates immense anxiety for many visa applicants. Truly, I mean, if you have your visa refused, what are your next steps? So, today we are going to discuss how to overcome your 221G and other consular challenges. And definitely, let's make this a very, very interactive session as well. I'm very happy to tell you, you can even participate in this. And all you have to do is comment. If you have any questions, especially regarding this topic, just comment, put them in the comments, and we will save some time to take up your questions for sure later in this session. So, thank you so much. And if you have ever faced that dreaded refusal or have been stuck in administrative processing, you know how confusing and frustrating it can really get. So, thank you so much for joining because we have got you covered in today's session. And joining us today to uncover and help us navigate through all these complexities, we have with us Justin Rivera, an expert in immigration litigation from Wasden Immigration Litigation. Justin, thank you so much for joining us once again. Really happy to have you back on our show.
Thanks for having me. Not sure if you could hear me the first time.
Absolutely. Justin, so maybe you could tell us what can folks expect from this session today?
Yeah, I think that it's good to kind of get an overlap of the consular process, applying for a visa at the consulate, just sort of what issues are typically encountered, what are the potential pitfalls. I think that anyone who is familiar with the U.S. immigration process has a healthy and robust fear of, getting a 221G. There's plenty of horror stories that exist about people waiting, 6, 7, 8, 9+ months without any sort of update or remedy to their situation. So I think it'd be nice to kind of give an explanation of that, kind of explain what some of the issues are that could be causing the problems and what can be done, and also, unfortunately, what can't be done because the consulates do have the power of consular non-reviewability.
Absolutely. And trust me, folks out there, it's going to be a very insightful and a practical conversation as well. So, definitely, I would just say stay with us until the end and let's dive right in. So, Justin, thank you so much, for joining us today. And I'm very excited because I have questions prepared for you. And without any further ado, let's go on with this first one. So if an F1 OPT holder receives a 221G during H1B stamping in India, can they return to the US and legally work on OPT while awaiting their 221G result, even if the OPT expires within 2 years?
So I think the way to tackle this question is the idea of what is theoretically possible and what is likely an outcome. And what I mean by that is this: is it theoretically possible to enter the United States with an F1 visa that is still valid and has not been canceled if the person still qualifies for the conditions of the F1? So let's say if they're working on OPT, they're still engaged with that same OPT employer. Maybe, for example, that's the same employer that sponsored their H1B. Theoretically, it's possible that the person could attempt to re-enter the United States. The problem becomes what happens at the port of entry. And the reason why I say that is when you're issued the 221G, usually it's going to give you kind of a vague justification as to what it's been issued for. Rarely, but sometimes it'll be a specific thing like a document. In that circumstance, you're not going to worry about waiting, having to wait. It's you literally get an email, you submit this document, you send it, they finish the adjudication. The problem becomes when people's cases get put into what's called administrative processing. And when that happens, the cases tend to be sat on. Now, the thing with that is the consulates have the ability, if they believe that there has been a fraud or misrepresentation made in relation to an application for an immigrant benefit, an immigration benefit, they have the ability to basically pause a visa application and recommend, usually it's a site visit for an H-1B, recommend what's a site visit in order to typically verify information in relation to the H-1B petition. Now, that being said, the issue becomes, is the problem with the 221G that's going on in relation to a fraud or misrepresentation that has been either entered already by USCIS, maybe in relation to this person's F1 status, or is it an investigation into the employment on an H-1B that also deals with that prior employment on F1 status? All of that is to basically say, the idea is, could you be able to do it? I think you could be able to, but the problem is when you do and you're trying to enter the United States, what happens at that port of entry? Are you taken into secondary inspection for additional screening based on the issues that have been raised in the 221G? If that's the case, the problem becomes, what finding is made there. And if a finding is made where your visa is canceled, what's going to happen is they're going to cancel your visa and they're probably going to put you into expedited removal. And if you're placed into expedited removal, you're removed from the United States, and that removal order carries a ban for a set number of years. And that, of course, is very problematic because then you no longer are able to utilize that visa. But even further, you have a ban from the US that you're going to have to deal with overcoming. To really complicate the circumstance even more is, on top of that ban that could be issued as a result of the expedited removal, you'll also be hit with a justification for your inadmissibility. And so there's a series of different reasons why someone can be found inadmissible. And it can be a litany of things. I've seen things like possession of controlled substance. There's drug trafficking, crime of moral, someone had violated a crime of moral turpitude. But the thing is, the big one that is a very big problem that unfortunately the CBP officers and the consular officers seem very willing and ready to hand out is a finding of fraud or misrepresentation. And a finding of fraud or misrepresentation is it's almost an immigration death sentence because it carries with it the potential for a permanent bar from the United States. And yes, it is possible for that to be overcome with waivers, but you're also going to see you're going to go from having a typical immigration case to an incredibly complicated immigration case. And so as a result of that, I would say if you're in that circumstance and you're considering traveling back to the United States while that 221G is pending, I think that it's a risk. I think that it's a significant risk. I think that ideally it would be possible to do, but I don't know if I would necessarily recommend that course of action. Maybe, honestly, if you were that worried about it, maybe even consider withdrawing the H-1B application, if possible. That's not necessarily going to remove the problem, but it'll at least take the pending 221G off the table for you. But then I still think, you're looking at coming into the port of entry, you're still possibly encountering issues. Oh, man, and now we're having connection issues.
All right, Justin, I think I lost you there, but it was, if you could just continue from where I left at, would be great. I think you're on mute. If you could just check, unmute yourself.
Okay. Let's just wrap that one real quick then and move on because I know we got a whole lot of other questions. Long story short, theoretically you could do it, but it would be I think it would be a risk.
Absolutely. And I think it's very important to stay legal and abide by all laws. So keep that in mind, friends. Thank you so much, Justin. And let's move on now to this next question, which I have for you. And this is regarding the timing for consular interviews amid 221G risk. So, if other applicants are facing delays due to 221G administrative processing, should an applicant proceed with their H1B consular interview immediately, or is it advisable to wait for a few months as suggested by the employer?
So I think what would be important in this determination is why are those other 221Gs being issued? Maybe what's the basis? If it's minute things like they're requesting more information on an incomplete application or something like that, then I don't think it'd necessarily be terrible to apply because you're probably in a completely different circumstance than that person. I think the individuals that I would caution about applying are people who have a similar fact pattern to people that are increasingly getting 221G to the consulate. So that could be like one of two things. One, is their H1B employer is their H1B employer someone who's seen an uptick in 221Gs and site visits?
Mhm.
If that's the case, what's probably happening is either FDNS, who works for USCIS and does site visits, either FDNS or the consulate abroad has recommended a finding of fraud in relation to an H-1B petition. Now, that finding of fraud could be wide reaching in that it could be an allegation such as an in-house project that allegedly exists does not exist according to their records. And so what happens is you see sort of that conclusion bleed out into other cases that have that project associated with it. So what, let's say for example, you have 6 people who were all sponsored by company A for an H1B in the lottery, and they were all selected. And they go, and the first 2 people get hit with 221Gs, and they're put in administrative processing. It's possible that they're being investigated for fraud in relation to an issue that's popped up on one of those applications. And if on top of that you're seeing the petitioner get site visits, repeated site visits and inquiries, it's probably an issue. And in that circumstance, yeah, I would wait because you're going to want to see how the 221Gs play out for those individuals. Because at the end of the day, there's going to be an adjudication. They're either, well, typically, they're going to either end up refusing the visa and they're going to give you a refusal sheet, or they're going to call the person back in to finish their interview. So that's really kind of the options of how it's going to play out. So I would definitely say if you're in a situation where you have the ability to wait and that's your fact pattern where you're seeing this uptick, people getting 221Gs and they're on the same with the same employer as you and maybe working in the same project as you, I would probably caution that. The other thing that I would consider too is looking at if you were an F1 and you were employed, making sure that none of those employers have actually ended up becoming what we're calling blacklisted, um,
Okay.
because because that's kind of the other thing that you have to look at for a probable issue. If you're seeing an uptick in people with 221Gs, perhaps you and other people at the school you went to all engaged with the same employer, and that employer has subsequently been blacklisted for violating OPT by whatever reason. I mean, I've seen cases like there are employers who claim that you have to pay them in order to work for them. It's called payment for an offer letter or something like that. if USCIS or ICE is able to basically put that link together and see that that company is participating in that kind of activity, they are often blacklisting a company, and it has a very wide-reaching effect, and it's almost, it's retroactive even in its application, and that it's basically going back against other people who've been maybe worked with that company, and it's been 4 or 5 years later and they're on their H-1B working. They had no idea. So I
Mhm.
think those are kind of the two big things that I would look at for the 221Gs if that's happening, and whether or not you should wait. Um, because yeah, I mean, I think that that's really it. Now, the idea that, because I've heard this kind of theory touted before of like, oh, they're issuing more 221Gs at consulate A, so don't go to consulate A. I'm not sure that that necessarily holds that much weight. Supposedly, the consulates are taught, by basically like per country, they're taught to apply standards the same way. So I don't know if it's
Yes.
necessarily true that that's the case. That being said, I have heard other practitioners basically say things along the lines of like, do not go to that consulate. I don't want you to be there, period, if it can be avoided. So I don't feel that way necessarily about consulates. I'm more about that with ports of entry into the U.S. So, for example, just a general thing to everybody on here: if you can avoid it, don't go through Abu Dhabi. Just don't do it.
Okay. Okay. Thank you so much, Justin, for that wonderful tip in the end, and thank you for taking that up for us.
Mhm.
Also, I think we have so many questions. Thank you so much, Ajay and Pavan, for your questions and for joining us. And quickly, let's go on to this next question that I have for you. And this is about handling an RFE challenge for OPT applications. So, if you could tell us in short, how can applicants effectively respond to an RFE for OPT if their college is known for issuing a higher number of RFEs, especially if they are living off campus to maintain legal status?
That's interesting. Regarding the applicability of living off campus to maintain legal status, I don't know if that really would that's not something I've necessarily encountered as problematic. Um, Perhaps that's a trend now that I haven't yet seen in the justification for an RFE being issued. Typically, what I see on an OPT RFE, generally speaking, what they're going to be asking about is maintenance of status. So that's,
Mhm.
how have you been complying with the requirements of, if it's for OPT, your curriculum requirements. And then for STEM OPT, they look to what the OPT requirements are. So for that maintenance of status, you're really going to have to work with your school and the DSO to provide the documents that are being requested. If it's for initial OPT, sometimes, and even STEM OPT, they can ask about the E-Verify for the employer, meaning that they're asking whether or not that employer is in the system called E-Verify, which is required in order for them to admit the person and allow them to work on OPT and grant that EAD. So that's something I've seen before. Another thing I've seen that's a kind of a bigger issue with some of the newer. Over the last couple of years, what they've done is they've kind of expanded what qualifies for STEM OPT. They've opened it up a little bit more so that there's more fields that STEM OPT falls into. As a result, what I've seen is there's been a little bit of an uptick in the issuance of RFEs for STEM OPT, where basically the officer is questioning, the immigration officer is questioning how that field qualifies for STEM OPT because it doesn't necessarily match up directly with the
Mhm.
codes that they're looking at. So that is something I've seen in that circumstance. What we've been able to do is work with the school to basically get a letter from the school to show them, to kind of show like that the person does meet the standard based on the fact that the school has to place them in a category and this is a new field. So this is the kind of, category that they've been placed in, but it does work. Um, so yeah, other than that, the other big thing that I think people should be aware of too, that definitely can come up for the RFEs is going to be that maintenance of unemployment time. You're only permitted so many days of OPT unemployment. If I remember right off the top of my head, it's 90 for OPT, 150 with STEM OPT. That 90 is one that gets questioned a lot. So I think that that's something to also be aware of, because you also have to be meeting the requirements or working the
Mhm.
requisite amount of hours. For OPT, you don't have to be paid necessarily, but I will say from personal experience, unpaid internships do seem to get a little bit more scrutiny on them than paid. Just for whatever reason, the service tends to look at unpaid internships, especially if it's the initial OPT. If it's the initial OPT and it's an unpaid internship and it just happens to be for a period of 3 months or 2 months, there does seem to be a little bit of scrutiny with, oh, okay, you hopped onto this employer because you didn't want to get OPT unemployment days. And
Mhm.
is this a valid employer? Is this a legitimate employment opportunity?
Mhm.
But other than that, I think that's it, the 90 and 150. And then a last thing before we move on, because I know we do have other questions, but this is really big because it relates to a case that I'm working on right
Sure.
now. And that is this requirement that people must be aware of in case they haven't been told. You have to be paid on STEM OPT. It is not
Keep
like
that in
OPT
mind.
where you can do unpaid internships. You have to be paid on STEM OPT. And if you are not paid on STEM OPT, USCIS will consider that a violation of status. So that is something to be cognizant of when you are
Mhm.
going to apply for that STEM OPT. Having the understanding that you do have to make sure that you are working for money, that it cannot be unpaid. And
Mhm.
so, just everyone is aware of a horror story that in relation to that, there was an individual who unfortunately did not realize that, and they worked unpaid on STEM OPT for several months. They ended
Okay.
up going and getting an H-1B, and the H-1B was approved. And they came into the United States and they got pulled into secondary inspection for an interview. And at the interview, they were basically told, we are aware that you worked for a couple of months on STEM OPT unpaid. And they said, yes, didn't realize that it wasn't against the law, right? And they said,
Mhm.
okay, well, when you filled out your DS 160 for your H-1B, you did not admit that you violated F1 status. And she tried to explain, well, how would I know that I violated F1 status if I didn't realize I couldn't work?
Mhm.
I had to be paid to work on STEM OPT. Um, Long story short, that person's visa was canceled and they were removed with a fraud and disability finding. And that person, through my eyes, and I think the eyes of any reasonable actor, would conclude they didn't intend to do that. There was no
Mhm.
intent when they filled out the DS 160. They weren't trying to pull one over on the government. They genuinely thought what they were doing in the moment was correct. But that's not what they care about when you're coming in at the port of entry. What they see is that you got popped in their system for something and they know that they can get you for it. So again, I'm sorry for the diatribe, but it's just I saw that, and to think that this person went through all of the work to get their H-1B approved, to go to the consulate, to get their H-1B stamped and come back in and then have that happen to them. It's just horrible. And all of it just comes from the fact that,
It is.
in my opinion, that person's DSO didn't do their job. They didn't do their due diligence. That person's DSO should have made more of an effort to make sure that this person was aware that they needed to be paid while they're working on
Exactly.
STEM OPT. But at the end of the day, they're not going to give you the benefit of the doubt. Ignorance isn't going to save you in the eyes of these individuals. And so as a
Mhm.
result, everyone needs to be aware of what the requirements are for both OPT and STEM OPT.
Absolutely. You have to know what the requirements are, what the law says, and abide by each of them, and stay out of anything that's fishy, and make sure that you get paid, especially under OPT.
For
Thank you,
STEM, yes.
Justin. Yes. Thank you so much, Justin, for taking that up. And we have some questions. I think we'll quickly take up this one from Rag on YouTube. Rag says, off late, premium processing invites an RFE. Is this real or a hoax?
So that's a really good question, and I actually think that's something that we debate as attorneys within our own field as well. And the
Mhm.
reason for that is I think it might come down to what type of visa is being applied for. And so what I
Mhm.
mean by that is this: I have heard it's kind of like widely held ideal at this point that EB2 NIW, if you're going premium processing, it's just a pop RFE. I mean, it's just going to
Mhm.
come out. And it's a generic RFE. And the idea is that the RFE is being issued because an EB2 NIW is a complex application. The adjudicators don't want to have to adjudicate it within the timeline of premium processing. So they put the
Mhm.
RFE on it to buy themselves time. Is that true? Is that not true? I'm not 100% sure. All I'm saying is people who have been purporting it seem very certain that that is the case. So that being said, does converting another type of case invoke an RFE? Is an H-1B more likely to get an RFE? Is an L-1 more likely to get an RFE simply because it has been in premium processing? I don't necessarily think so. I don't
Mhm.
necessarily think that's the case. I think it's more so just what are the issues you're looking at within the petition. You got to realize when you're moving up your adjudication timeline from,
Mhm.
X amount of days, 90 days, whatever, to 15 days, you're going to get your result much faster. And sometimes that result is a request for evidence.
Mhm.
So yeah, I definitely think that that's out there and it's something people talk about, but I haven't seen it firsthand except for the EB2 NIW. I will say, I think there may be a possibility that there's an uptick in RFEs, but then it kind of creates the problem, right? Of, well, do you wait in regular processing? How
Mhm.
long are you waiting? Or do you convert to premium with the understanding that, yes, you might get an RFE that's going to be cumbersome and tedious and difficult? So it's really what's your risk tolerance in that circumstance.
Okay.
But other than that, no, I don't think I don't think it's necessarily just. I don't think you just because you're upgrading to premium. I don't think you're for sure going to get an RFE.
Yes. Thank you, Ralph, for your question, and I hope that you've got your answer. Thank you, Justin, for taking it out. Well, Justin,
Mhm.
we have some of the YouTube comments which are relevant, and we really want to take some of them up from our previous webinars that we've had, and let's take them up one by one. Let's go on with this first one. I was refused 221G. My case status changed from refused to ready. My medical examination and my passport at the embassy. What does this mean?
I was refused for a 221G. My case status changed from refused to ready. Medical exam and passport at the embassy. If it's been changed to ready, that typically means that you're approved. Usually, that's been my understanding is that that means you're approved and they're going to be issuing the visa. If that happened and you haven't received anything,
Mhm.
because usually what they're going to do is send you an email or something saying to come in. And they have your passport as well, which is always a good sign. When they take your passport, that usually means we're going to figure this thing out, relatively quickly, and because otherwise you're not able to travel. That being said, I will say that I have one story from practicing where the individual actually went for L1 stamping in Mexico. And they went for stamping in Mexico, and it was approved, no issues. They thought, and they turned in the passports, and a week goes by, they haven't got the stamping. They haven't come in to get the visa. 2 weeks goes by, and the guy started to freak out because he's got to come back into the U.S. His kid's got school, his wife's got a job, and so they don't understand what the heck is happening. They're like, why are we not getting our stuff back? It
Mhm.
turned out, unfortunately, that the emails from the consulate had been going to his junk mail. And as a result, they had actually reached out to him multiple times to come in, and he had never responded to pick up
Mhm.
his passports. So that can happen, I suppose. Another time, I had an issue where the consulate just forgot. They just straight up forgot to tell the guy.
Mhm.
And in that circumstance, I know it sounds crazy because, I get it. Not all, in some of these countries, the consulates are intimidating and they won't let you in. But in that circumstance, I actually had the guy go physically to the consulate and basically explain, like, hey, you guys have had my passports for X amount of days. I'm not sure what's going on, but I need, to go back to the U.S. My whole family's here. I'm in a hotel down the street.
Mhm.
And they ended up having a manager, like a supervisor, come out and
Okay.
Sorry, I'm laughing, but it's still amazing to me to think about. They had a supervisor come out and tell him, "Oh yeah, you're approved. Sorry, we just kind of didn't get to your stuff." And it had been weeks. And they literally told him, "Go down the street, have some lunch, and come back, and we'll give you all the passports, and you'll have your visas in there, and you're good to go."
Crazy,
So
but
yeah, it was crazy to think about, because you got to, like, the consulate's not infallible. Like, these are normal everyday people doing jobs. It is completely possible that in the hundreds, if not thousands, of cases they're dealing with, you're going to see situations where someone slips through the cracks, and unfortunately this person slipped through the cracks. So yeah, I mean, it can happen. So I would say for this individual, if you have the ability to, maybe just reach out to the consulate, just see if they're willing to provide you with an update. Hopefully they gave you an email address to correspond with to them, and they'll hopefully be telling you to come in.
great. Thank you so much, Justin, for taking that up. And I still have so many more, so I'll just quickly move on to the next one now.
Oh, that's
So this
tiny.
is from Midnight Bloom. Hello, I was refused under 221G. The embassy requested my passport and medical examination, and I sent. My case,
This
sorry,
kind of seems like it might be the same issue. Yeah.
the same one. Yes, yes. So I'll move on to this one. Hello, me and my fiance need help with the 221G. She was instructed to send more documents via DHL. In order to do this, the instructions they gave tell her to sign into her account on a website. Click on the option that says, Yes, consular has inducted me to send more documents. However, the option is not visible. What are the reasons for this? Does it take time to become enabled after the interview? We have the documents but can't send them, and nobody will answer us, not even the number they provided us. Thank you so much.
Jeez. Yeah, that's not something I have encountered before. I will say, generally speaking, does it surprise me that their websites don't function properly? Absolutely not. I really, they're not well put together, in my opinion. So it doesn't shock me that that's an issue. That being said, unfortunately, this is a very real situation for this person, because they're basically being told to do something that they don't have the ability to do, and clearly they're not getting responses from the consulate. Um, usually, I would
Okay,
say you try to.
frustrating.
Yeah, I mean, usually I would say you try to email. Sorry, that's my dog back there. Uh, Usually I would say you try to email them if possible, but I know that it's difficult sometimes to get them to reach back out to you. Maybe have an attorney to try to represent you and reach out. They might get a little more leeway and a little more pull, just as a result of
Mhm,
being a licensed attorney. Um, Other than that, you're not really in a great circumstance, because there's no way for you to submit the docs. You could try submitting them via email, just to whatever email address you can find for the consulate, with an explanation that you're not able to provide them through the website like you've been instructed, and you've been waiting
mhm,
X amount of days, and as a result, you're just trying to find a solution to the problem. So that would be something. Like I had for my other individual that one time, maybe you could try going to the consulate to explain the issue. That being said, what happened to the individual I was working with may have been an outlier in that situation, because I know, generally
mhm,
speaking, if you don't have an appointment, they're not supposed to let you into the consulate. And so it's very possible that even if you try to go in, you're going to be turned away. At the same time, maybe if you're able to explain yourself thoroughly, and let them know, and bring the documents literally with you in hand, to say, look, you guys asked for this. You want me to upload it here, but I can't. There's literally no way for me to upload it. What is my workaround? Then you
mhm,
could get some traction, because that's really all I can see you being able to do. And at the end of the day, I think for a lot of people that deal with the consulates, this is the big problem with the consulate. It's the way that the consulate can just basically shut you out, and not, there's no obligation. They don't have to give you a follow-up in a set number of days. They don't have to give you status updates. That's not There's no customer service system for the consulates. And frankly, they don't
Mhm.
care because they're the only game in town. There's nobody else doing this. So you're stuck with the services they provide. I know that personally because I'm, literally in the
Crazy.
process of dealing with the Canadian consulates on something, and they will not be responsive. It's incredibly frustrating. So I get it. But that would be kind of my general advice on what to do. If that doesn't work, maybe I don't know, maybe try even looking to see if there's an attorney that you could utilize their services that has experience with working particularly with those consulates, and maybe see if they have some other workaround.
Crazy, but very frustrating. Thank you so much, Justin, for sharing your experience. And there you go, friends. Thank you. And let's move on to this next one now. Hello. In my case, I have an F1 status to H4 status. I am in USA, but I just have the status, not a visa stamp. Would this process be the same for me? And once I upload my documents, do I need to keep studying during the processing time? This is from
Um,
Alejandra Diaz.
so I'm a little confused on this. I'm going to take this based on my understanding of the question being that the person was wants to go from F1 to H4, but I have the status, not the visa stamp. Okay, so maybe you filed an F1 to H4 change of status, and you're now on H4, and you're asking what are the requirements of it. Once you're on H4 status, then you're just bound to the conditions of the H4. It's a dependent visa, which means as long as your primary is maintaining status, you're maintaining status as long as you're not
Mhm.
working without authorization. So do you need to study while you're on the H4? No. Once you've changed status over to the H4, you're not bound by the conditions of the F1. So that means you're not, you don't have to maintain a full course of study or all the other caveated qualifications of the F1. That all being said, when you go abroad, you will need to get an H4 visa. You have to because you're in F1. You're going to be moving over to H4. The
Mhm.
H4 visa process, it's pretty straightforward and simple. You schedule the appointment. The only documents that you really need, as long as your spouse is already in valid H-1B status, is going to be a copy of that H-1B petition. Not petition, a copy of the H-1B approval notice, maybe a letter from the H-1B holder's employer. Your marriage certificate is the big one, with an English translation if it is not in English.
In English.
You'll need that as well. And then if you want to be really cautious, maybe the most three recent pay stubs for the H-1B holder. And those are really the only docs that you need when you go in. H4, if you go and have an interview, real straightforward, real easy process. Is this who you're married to? Are they working on an H-1B? You're pretty much good to go. So again, I've very rarely seen people refused H4s. The only time I've ever seen H4 refusal issues is in relation to inadmissibility findings. So that's where someone had a violation maybe on a previous status and got hit with an inadmissibility finding for some reason, but pretty rare. So outside of that, it's pretty straightforward and simple.
Thank you, Justin, for taking that up and for answering that. Now let's move on to this next one. We have this from MP5692. Hi, ma'am. My visa due to expiry on the 20th of November 2024, but PED already expired on visa. However, I've extended I-797, I-29S till December 2025, L1 extension. I would like to travel to Canada for fall holidays, 5th to 12th of October, which is already done. Is there any risk of re entry in the United States via road border or denial at US border for re entry? I think there was more, but that is the question. Justin, if you can help us with an answer. So the question is, will there be any risk to re enter the US via road border?
So with the U.S. and Canada, there's automatic visa revalidation that kind of operates as a cover. Where I think it's if you're in the in those countries that are directly tied to the U.S. by physical land border, that's like Canada and Mexico. I think it's for a time period of less than, oh gosh, less than 20 days or maybe 30 days, but it's one of those two. Then automatic visa revalidation could be okay and permit travel in that circumstance, so that you'd be able to leave and re-enter. But at the same time, I think the most cautious option would obviously be, you're going to need to get a new visa. That also being said, though, well, I guess if they have a visa, it's not the case. But if they're going to Canada, if they're a Canadian, then they don't actually need the visa in the first place. They can actually just
Mhm.
travel with the new I-129 I-797 approval notice with the I-129S, and then they're able to leave and come back in without issue.
Okay.
So yeah, I would say maybe look into automatic visa revalidation, but don't exactly quote me on it. I would look into it more before making a decision there.
Yes. Thank you, Justin. Thank you for taking it out. Well, Bikram Rao, what are we discussing today? We are discussing if you have your visa, if you've got your visa refused, what are your options and how to overcome a 221G and other consular challenges. So thank you so much for joining us. And we
Mm.
also got another question. This is from Khatak. My visa approved at consulate after 45 days. Status changed to refused after 4 months. They sent after 4 months. Sorry, there is no punctuation and I'm not knowing where to stop. They sent back passport with green color 221G paper with no additional documents. Is required. What does this mean now?
Uh, that's
What is
interesting.
this green color 221G paper anyway? There are different colors. There's a pink, there's a yellow, I think, and there is
Yeah.
a green.
So usually the color is going to be applicable to like the justification for the 221G or what it is that is specifically at issue.
Mhm,
So a green one, it looks like from what I'm looking at here, is in relation to the applicant not providing enough information, or that the application needs additional administrative processing. I mean, I think I would probably need to look at the actual 221G itself, but I'm not
mhm,
necessarily super familiar with each color as much as I am to what the sheets actually look like, the physical sheets that are
okay,
emailed or provided in person. Um,
mhm,
that being said, Council 45 refused after 4 months, and they sent it back with 221G with no additional documents. What does it mean? I mean, if the 221G doesn't have a specific box selected, if it doesn't say anything, I think then that kind of just defaults to additional administrative processing.
okay,
That's not great, because that's kind of
yeah,
I think that for a lot of times that's where people are worried that their case is just going to kind of lag in perpetuity. Um, I would probably say, in this circumstance, how long has your case been pending for? And then how many times have you contacted the consulate? There
mhm,
are ways where you can actually, I think it's going to be difficult for this person because there's not a specific justification as to what's going on with the 221G, but maybe possibly look into seeing if you can reach out to the consulate and see if they're willing to provide you an update. If you reach out to them on more than, I believe it's more than 2 times after 30 days of pending processing, it may be possible for you to raise what's called a legal net inquiry. And that's where you actually use the State Department, and get the State Department to review what's being done by the consulate. The thing about that is, for the legal net inquiry, is you have to have a specific legal like justification. There has to be a question as to what's going on in relation to the case. So like, to give you kind of an example for that, I worked on a case where someone had they had an O1 that had been pending for I think it was 3 months, and they had reached out to the consulate twice and basically gotten generic messages back. We did a legal net inquiry because our understanding was the whole basis of the 221G was that the consulate officer was confused about how the O1 was structured. So we basically
mhm,
did a legal net inquiry, and the inquiry was, can the officer refuse the visa because of this, like the structure of the O1, which is valid? does not comport to like their traditional understanding. And without going into too much detail about how that worked, is we did that. We had to wait a couple days, about close to 30 days, and after that time frame, the consulate emailed the client, said the Visas Act is available. You need to come submit your passport. He was able to travel back to the country where the consular interview was and submit his passport and get approved. He's now in the U.S. working subject to his O1. So maybe that's something that can be explored for this individual. I would probably need more information.
Yes, Katak, that is what I wanted to say. Thank you so much for your question. But you can always have a one-on-one consultation with Wasden Immigration Litigation, and even write to Justin Rivera himself. His phone number is 844-592-7336. You can even email support@wasden.law, and go visit www.wasden.law to get to know more about them. All right, Justin, thank you so much. And we have Rag now asking another question. There's a
Mhm.
follow-up. Most common reasons or patterns for 221G with L1A and H1B, if you could quickly just highlight some few points.
Sure. So really with the consulates, what they're supposed to do is they're not supposed to re-adjudicate the petition. And what I mean by that is this: the USCIS has already made the determination. Well, for an L1A, if they have a blanket, they could be applying at the consulate. But let's say hypothetically, USCIS has adjudicated the petition. If USCIS has already adjudicated the petition, they've already satisfied the parameters of the person's qualifications. H1B specialty occupation, the person's qualified. The L1A, manager, they're managing people in a function, a specific function, or a set number of individuals, and they qualify. Long story short, so what could possibly be encountered at the consulate that could lead to a triggering of a 221G? For the H1Bs, I've seen. For me, most recently, what triggers the 221Gs for the H1Bs seems to be a need to verify information in the petition. That could be because of a statement made during the interview by the individual. For example, maybe the individual said, I work at this end client, and this end client is located here. Well, the officer, using the power of Google, does a Google search, and it says, well, I don't see that address. The client's not at that address based on Google. So I'm going to issue a 221G. That could happen. And in that circumstance, it's not as if anything nefarious or untoward is happening. They're probably going to recommend a site visit. Officer will go check it out. They'll say, yeah, we're the end client, and that guy's going to come work for us, and then you have no problem. The negative side of that is, you get a site, somebody who comes in and makes a completely incorrect statement, and it requires further administrative processing, and a 221G is issued. And then they start really digging into what's going on with this person's petition. Then you could see an issue where you see a site visit, multiple emails, where you're going to be getting the employee getting emailed, the employer getting emailed, the employer maybe if they have an end client, being asked for the end client's information so that they can verify that stuff. Those are really the difficult situations, because that's when they're gathering so much information. As the pool of information gets larger, the possibility for there to be a problem increases. So that's, my dog just hit a toy. Sorry.
It's all right.
Um,
It's all right. That's good.
yeah. So regarding the L1A, I have actually not seen very many 221Gs issued. The only one that really comes to mind for me for the L1A specifically was a circumstance where the individual apparently made a statement where they misspoke about the number of people that they managed in their U.S. position. And the problem was that because just that statement, and it was literally a numerical issue of 8 and 6, the petition said 8 and the person said 6. And honestly, what had happened was, from the time the person's L1A had been approved to when they went to the interview, there had been a restructuring. There had just been a change in the number of people that this individual managed. However, the information conveyed to the consulate had not changed. The petition information was not different. So the information that was handed over and reviewed didn't match the words that came out of the person's mouth. Well, right there, if you're an officer, you can kind of make one of two choices. You can clarify like a normal human being, or you can be a jerk and issue a 221G. And that's what they did in that circumstance. They issued a 221G. pretty much from our understanding, purely based on that misstatement. And then ended up reaching out to the employer to verify the number of employees working under this person. It was a litany of back and forth, just nonsense and a waste of time all over a slight misstatement. So
Mhm.
all of that comes back to say, when you go to the interview, I'm not saying that as a default that the consular officer is adversarial. I don't think they usually are. I think a lot of times consular officers, they have a lot of cases to review. They have a lot of people to get through on a day-to-day basis. It's likely that unless you have something in your record to tip them off, they're probably not looking to do anything to your case. They don't necessarily want to deny you.
Mhm.
Um, but you do have to meet them halfway. And what I mean by that is you do have to make sure that the information you're conveying to them matches the information that's been provided in your petition. And that requires at least a basic review of the information of what it is that you're said that it says you're going to be doing. Because it's very easy to make that mistake. It's very easy to slip up and say the wrong thing on accident, and then you're backtracking from that time forward, and you've already kind of put yourself at a disadvantage with the officer. So that's what I've seen for both the L1s and the H1B overall. I will also say that most of the L1As I've done recently have been blankets. So in that circumstance, you're actually applying at the consulate. And I haven't really gotten any issues on that. I literally had one case, I think, one case that got held for like 2 days because they got the number, the blanket petition number was off by
Mhm.
one number. And because it was wrong in the petition, they issued, yeah, and we even had the right blanket approval notice at the interview. But they said because it was wrong in the form, and I know the poor guy, he even offered to take a pin and change it because I think it was like a 4 to a 5 or something. And the officer, for whatever reason, was like, no, I'm going to give you a 221G. And then your attorney of record has to send me the right version of the form, which is literally one number changed. And then I'll grant
Whoa.
your case. Now, that being said, they have the power to do that. They have the authority to do that. But yeah, outside of that, I really haven't seen that many issues in terms of refusals. The one thing I'll say for L1s that is it's kind of a default that is pretty much well known if you're versing in the L1s. You have the L1A manager and you have the L1A functional manager. So the
Mhm.
manager is a people manager. People manager is very easy to show. If I manage 4 people, then I can show you an org chart with 4 people. It's not hard to really get that information across to someone. A functional manager is someone who manages an essential function of an organization, something very like specific part of an organization, and oftentimes it can be hard to show that in a chart or a graph, and it can be difficult for the individual to articulate because what you're doing is trying to explain something that might be somewhat complex to someone that has, as the consular officer, no real understanding of what the hell it is you're telling them. So I would say for that, what I would say, like, if you're an L1A functional manager and you're going abroad for visa interview, I think you need to be doubly prepared. You need to probably really hone in on how you're going to be explaining things to the officer. Because I've seen those cases approved for sure. I'm not saying it's, a situation where you're not going to get approved just because of the being functional manager. But I think they require a little more care than the people manager, just because it's more difficult to get the information to the across the officer.
Absolutely. And I think, yes, whenever, especially during filing your forms, you have to put 100% head in the game so that you make no mistakes, silly mistakes like these, which could, be very heavy on you a little later. But thank you so much, Rag, for your question and for Justin for taking it up and for explaining it in so much details. I had more questions, but now I'll quickly take them from our Facebook groups. So
Okay.
let- let's go to them quickly. I have this one. This is an anonymous one. I changed my status from B1 to L1A visa inside USA, and I have approval I-7 797 valid until March 2025. But when I went to my home country in emergency, I went to the embassy to get a stamp. I entered in AP 221G without documents from September 2nd, and it updated four times, but until now, I didn't see any update or response. Can anyone tell me if any hope is in this case to get approval soon? I left my home, my car, and my money in USA.
I entered AP 221G without documents. Okay. From September 2nd, and it updated four times, but until now I don't see any update or response. If you've been sitting at a 221G for that long, I would probably contact an attorney and consider trying to do a legal net inquiry. Um, you're going to have to be more specific with the issues related to your case, and you're probably going to have to describe what happened in your interview, and explain, why it's possible that the 221G got triggered. Obviously, provide a copy of the document as well. If you're sitting there that long, it's not a great sign. The Something we haven't touched on, to be blunt, is security and background checks as an issue for 221G. So that's a situation where basically the government says that someone, for whatever reason, has popped up in some capacity, even tangential, because of their relation to someone or something, as a security risk. And that means that they're going to say, you're a security risk. We're going to put you in for background verification, and they can stick you in there pretty much forever.
Mhm.
There's no real requirement for them to adjudicate to adjudicate the case in any particular timeline or order. Once it goes into that security risk too, then it becomes like a national interest thing, and they're going to basically say, we're probably never going to let this person in. An example of that, unfortunately, was a time where I worked on a case for a person who we were trying to get them in, and we could not get them in for whatever reason. We, did 221Gs anytime pretty much that they come in. We ended up doing a FOIA, Freedom of Information Act, FOIA, to try and understand what was it that was
Mhm.
possessed that made this person constantly ineligible for coming into the United States. Well, it turned out this person was the son of someone from the Middle East who was literally on the terror watch list. Yeah. So yeah, and what was crazy about it was this person never told us that. Throughout this entire process, they seemed to act as if they were like, why can't I come into the US? What could it be that's keeping me from my entry? And we're sitting there thinking, we're preparing all of this stuff correctly. What's going on when he goes for these interviews? And so, yeah, could not get him in. And then we found out that, and I'm going to tell you right now, if that's a circumstance for you, I'm sorry, you're never getting into the US. It's never going to happen. Like, it's just not, they're not making any exceptions for anybody. And I did feel bad for him because from my understanding, it didn't seem like he had like a relationship really with that person, but as a result of their biological relationship, he was on that list. He was never permitted in. To my knowledge, still has not been. Got to a point once we got that information, we were like, here, we're out. We can't do anything for you. So yeah, that's unfortunate, but maybe based on your circumstances, that individual could qualify for a legal net inquiry. We would just need more information.
Yes. Thank you, Justin, for taking it up. And I think we will go with our last one for today. And if we still got time, we will take up another one maybe. But let's take up this one. This is also anonymous and says, hello, guys. It's been 153 days since I am in 221G administrative processing for my F1 visa application for PhD course. I have applied along with my dependents. My consulate was Islamabad, Pakistan. Every time I email them, they give me this formality response that it takes 180 days. My semester is starting in January 2025. What should I do? Should I wait or reapply? This delay is frustrating, and I have already deferred my semester from fall 2024 to spring 2025. People gone through relevant experience or situations like this, please give advice.
Wow. Yeah, that's a tough situation. I can say personally, I've not worked with the consulates in Pakistan before. So, right off the bat, I'm not necessarily familiar with those consulates. If you're in, I mean, 153 days, that's a long time for administrative processing. To kind of invoke the last answer that I had, I would be worried that you're dealing with an issue where it's a security clearance concern. That would be kind of my worry. Just because of the duration, if they're not requesting any additional documents or information from you, that could be why. This is another circumstance where, based on the timeline and the number of times the individual has reached out to the consulate while his case has been placed in 221G, it might be possible to raise a legal net inquiry. Again, you're going to have to get fact specific and get into what's going on with this person's case to maybe figure out what kind of argument you want to present the State Department. Um, so that would be my advice, is maybe look into thinking about having an attorney do a legal net inquiry for you. Um, Regarding reapplication, I think the problem with that is if you withdraw and reapply, there is nothing that says that you're not going to encounter the exact same issue.
Mhm.
I think whatever the issue is, seeing as it's been pending this long, it might be just related to you. It could be related to something on your record. And as a result, I don't know if withdrawing and reapplying is going to change anything.
Thank you. Thank you so much, Justin, for taking it up. It is complicated. Every case is different. So it's always best to have a one on one consultation and a detailed consultation about your case, which is very different from the rest. Justin, I would wrap up, but I got a question from a viewer on my WhatsApp, and I really want to take it up. This is from Heavenly Worldwide Ministry. Thank you so much for joining in. Is asking, in officer experience with applications that were denied under 214B, what key aspects do you recommend I emphasize on clarify in my next application to demonstrate my ties to my home country and intend to return?
Right. Oh, okay. Yeah. So this is not an uncommon denial for a visa. Unfortunately, it can happen. A lot of times, too, it's a difficult problem for younger people, because younger people don't typically own property, and they don't have a lot of justification to ties to their home country outside of what their relatives, basically their family members. Ways to show ties to your home country. I mean, obviously, depending on the visa type you're applying for, if it's a B visa, you need to show that you're coming in temporarily, and you're going to have the intent to return. So, what are the reasons why you're returning? You'd show family ties, property, a job is always good, because then it shows, I'm not abandoning my job by coming into the United States. Bank records, things like that. That being said, if it's an issue of non-immigrant intent, where you're trying to show that you're not going to be permanently coming into the United States, you're showing that non-immigrant intent. Same sort of thing, where you need to show you've got sufficient family members in your home country, if possible, um, an intent to return because you have something waiting for you back in your home country, be that maybe a job, or you have finances there in your home country, something like that. But really, I think it depends on what kind of visa you're applying for. For me, I've seen that 214B come up for the Bs, those B visas, and with those, the easiest home runs are going to be a letter from your employer. If you have children, a letter from your kid's school saying that your kid is enrolled in that school abroad, because it shows that if your kid's there in school, you're not going to be leaving the country. You're not going to be coming into the U.S. permanently. So you have a job in your home country, you've got kids in your home country, and then property in your home country. And showing all of that, it gives it's a pretty strong showing that you have sufficient ties. And then you bring it all home with the family members that you have in your home country as well. And that's typically
Mhm.
what I would bring. And I mean, it's not uncommon that you see that happen on these B applications. It's a situation where I think that um, if you don't come really prepared and you just kind of think, oh, I'll just walk in and say, it's a B visa. I'm traveling, for pleasure, and I'm going to be in here for 2 weeks. I have an itinerary. Then you're good. That may not be the case. The last big thing I think that's great to have if you have it is a round trip ticket. So show that you already have your flight booked to the U.S. and coming back from the U.S. And I think if you have that
Mhm.
along with everything else, you should be in good shape.
All right. Thank you so much, Justin. I know we could go on and on. There's so many questions pending that I would have loved to take, but I think I could appeal it to you right now that we could continue with this topic maybe again in our next webinar whenever you get a chance to come back again.
Sure thing. And as you said before, you're more than everyone here. Please, if you need to, reach out to us via email. We'd be more than happy to try and set you up and assist you with any issues.
Absolutely. And the email address is support@wasden.law. Thank you so much, Justin. It is a wrap. And thank you really so much to Justin, you, for sharing, all these invaluable insights under this topic we discussed today. And truly, you helped us navigate through some of the trickiest parts and questions that we had today, especially with regard to visa refusals and consular processes. Thank you. And
No
maybe
problem.
if you have any end note to wrap up, you might as well do that.
Uh, no, not really. I would just say as a last bit of information to anybody who is worried about, applying for a visa at the consulate, if that's an issue, I would recommend at least scheduling a consultation with an attorney to maybe do a visa prep interview. That's something that I often did commonly for people, especially people that are applying for L's, because you're actually applying if you're on that if you're using the blanket. But if you're going abroad and you're worried about, what are the questions I'm going to be asked? I have an issue in my past. Maybe you had a violation of F1 status in the past, and you're thinking, well, what's going to happen when this comes up? What am I going to be asked?
Mhm.
I think it's worth investing the time and effort into, a at a minimum, a consultation, so that you're able to be prepared, so that when you go to the consulate, you're confident and you're going to be able to make sure that you end up getting that visa.
Absolutely. And nothing else can be more confident than preparing ourselves. So, Justin, thank you so much today. And folks out there, the details are on the screen. Justin's contact details. You can always give him a call. You can even email him. And Justin is going to be back again with us to discuss more on this topic, I'm sure. So, thank you, Justin. I'll let you go for today, but I'm really looking forward for another webinar soon.
Thanks. We'll talk to you soon. Bye.
Bye bye. Thank you. And folks out there, you can keep commenting in case you're watching this video after the stream has ended. We would love to take up your questions. So keep commenting. And if you got your answers today in this session, please do not forget to like, share, and subscribe to our channel. We are Immigration and Jobs Talk Show in all handles, whether it's YouTube, LinkedIn, or Facebook. And thank you so much for joining in today. I have my number. Thank you, Heavenly, for sending me a WhatsApp message about your question, and my number is 408-335-6444. You can even email me. My email address is nipa@staffingly.com. And definitely go visit us, www.staffingly.com, to get to know more about us. I had a great time today, friends. Thank you so much for joining us. Stay connected with us, and definitely for more discussions like these, which can help you overcome immigration challenges and unlock opportunities. Until next time, don't forget to subscribe to us. All right. Take care. And yeah, let's do this. Keep pushing forward. Thank